All right. So anyway, so this meeting is being recorded. And anyway, I'm going to open the meeting. Everyone bear with us for another moment, please. And anyway, this is a meeting of the Zoning Board of Appeals, which was to be convened remote only. So if anyone went to the townhouse, they wouldn't find anybody there tonight. Present, we do have in the meeting the voting members of the ZBA, who are myself, Ethan Stiles, Suzanne Jafarian, and Dave Alberti. We have town council, we have the applicant's council, we have the applicant, we have the applicant's consultant, we have the applicant's hydrogeology expert. We have the board's hydrogeology consultants, and various members of the general public and other interested parties. So we pretty much, as anyone else comes in, I'll make sure to admit them. But I think, we do have enough people here to start the meeting. So with that out of the way, now tonight we're here to hear hydrogeology presentations. I believe from both the applicant's hydrogeology expert and from the board's hydrogeology consultant. Also, the Board of Health has also have its hydrogeology consultant who has submitted input. So we'll try to get to as much of that as possible. So now with that, does anyone wish to, does anyone have any ideas on who should go first in terms of presentations?
Good, good evening, members of the board. My name is Attorney David Hennig. I'm from the law firm Galvin & Galvin PC. I'm here on behalf of the applicant, Ricketts Pond Estates LLC. Also present with us in the meeting online is Mr. Peter Opachinsky, the principal in Ricketts Pond, Brad McKenzie, our civil engineer, and Peter Dillon, our hydrologist for the application. And I think it makes sense for us to start with Mr. Dillon. If anybody has any other ideas or objections to them, I think that makes sense where to start.
I would agree. Unless I hear any objection, I think we should hear Mr. Dillon first, and then we can go from there.
Okay. So I guess I think that and generally your consultant and I generally agree on the geology and the hydrogeology of the area, which is mostly based on USGS information, but also on-site test pits and the private wells that are next door. They basically confirm that it's a relatively thick deposit of sand and gravel, and groundwater flows from Ricketts Pond as a flow-through pond to the west southwest. So, like I said, in general, we agree. GEI made some recommendations, and then to meet those recommendations, we are actually going to install one of the final private wells, by a Massachusetts well driller, who will perform the required yield test, which is probably a little bit above and beyond the slug test that they asked. We can actually demonstrate that the well will supply the needed water for this unit. We'll take samples in accordance with the private well guidelines. With the exception of radionuclides, there's not a lot of radionuclides. If this was a bedrock well, I'd say yes, let's do that. But from past experience of testing radionuclides in the Plymouth Carver Aquifer, they're very, very low. The other thing is that they asked for residential use parameters in Table 12 of the private well guidelines. This site's never been used as residential, but it certainly has been used for mining, and the requirements for mining, along with some additional parameters that actually aren't in the guidelines, will be done. We'll do a full suite of analysis, and that will include PFAS, which obviously is the contaminant of concern these days. We're not proposing to do a surface water sample. Basically, the well is down gradient from Ricketts Pond. If there's contamination in Ricketts Pond, it's going to get to the wells, and so we'll be testing the wells. If we find anything, then in accordance with the private well guidelines, we'll Table 14 of the guidelines, we will install the appropriate treatment. My guess is that, as with some of the wells on the abutting properties, iron and manganese is going to be an issue, as it is everywhere in Plympton. And but we might find something else that needs some treatment. So all this will be done prior to any site modifications, with the exception of access for the drill rigs. And that was kind of a summation of the letter that you guys got the other day, and I think in general, kind of the overall. That's it.
All right, so we do have we have two letters here. One that's dated 12 December, and the other one was dated the other day. I think the other day was pretty much the response to our consultants' issues with your concerns with your letter, with your report of December. Is that correct?
That's correct.
All right. All right. That being said, how is GEI prepared to speak on the summary of their findings at this time?
Sure, yeah, I can provide a high-level overview of what we reviewed, and I think Mr. Dillon kind of summarized his summary was consistent, I think, with what we found with the aquifer properties, and we found that there would be likely, we were asked to take a look at the adequacy for overall aquifer yield and quality. So we took a look at that from an environmental perspective and agree there had been no, other than mining, no historical industrial sources of contamination nearby. So I think your acknowledgement to accept our recommendations for those, the sampling and that testing makes sense. We were provided today with a report from another consultant that had a lot more specific nitrogen loading calculations.
Well, let's take that. Let's take that for a moment. Is there anything else that you need to say specifically about what Mr. Dillon is proposing?
No, what Mr. Dillon is proposing would satisfy us, would be consistent with our recommendations from the information that we reviewed in our reporting.
All right. Okay. All right. We'll talk about the issue that Mr. Horsley brought up in a moment. But does anyone have? But at this point, I think it will be prudent to ask: does anyone have any questions or comments for either Mr. Daigle or Mr. Dillon based on what they've just said?
I would just ask, Tom, would you have any recommendations for the conditions of the permit based on your report and Mr. Dillon's feedback that you'd like that we should probably have the ZBA or recommend to the ZBA to include in the permit?
I think those things that Mr. Dillon said that they would do, I think should be conditions of the permit. Yes.
Okay.
The sampling and the analysis and the suite of analyses that we recommended in the yield testing for review prior to full approval. Yes.
Okay.
All right. I have a question. The things that are mentioned to be done about the sample testing, the drilling, is that supposed to come before any construction is started on the residences, or does that come interweaved with construction, or how does that?
That would be done prior to any site work whatsoever,
Okay.
with the exception of getting a drill rig out to the location where it needs to get to, if you need to maybe build a little gravel road or something like that. But no site work would be done until this is done.
All right. I thought that, but I appreciate your explanation, so I want to be clear. So, and another question I had, you mentioned iron and manganese. What if you do find elevated levels above, the maximum contaminant levels, or what generally is done about those types of issues?
There's a bunch of different treatment methods. Like I said, I would say that it would be my guess that probably at least half of the houses in Plympton, or actually in the Plymouth Carver Aquifer, if they're near a pond, have iron and manganese levels above the drinking water standards. There's a bunch of different ways you can do the treatment, depending. It would depend on what the levels were.
And
Cat,
with the,
cation exchange is typically the one when the levels are relatively low.
and is that done on a per unit or per home basis, or does it go generally to the water table from the common source?
If you look at the wells that on the adjacent development in mostly in Carver,
Mhm.
about I think there was only two of them, and I might be only one, had an iron and manganese problem. Usually when the driller comes in, he goes in and he looks for brown sand. Brown sand does not have the iron and manganese issues. Gray sand does. So I know the driller who's probably going to do this, and that's specifically what he will come in and do. So, like I said, it's a pretty common contaminant.
And has a driller been selected, or is that something you guys handle at a later time?
I can't say for sure, but my guess it will be West End Drilling who did all the other wells on the adjacent development, and looking at the records in the area has done a considerable amount of the others. For the overburden wells, these are overburden wells.
And I can confirm that West End would be the driller.
Okay. All right. I can't think of anything else to ask at this moment. Would anyone else like to ask, based on what we've heard so far?
Ethan, if I may,
Sure.
Dave Alberti, is it only one test site, or would there be a couple that are distance apart, or only one required then, per your assessments?
Right now, we're only proposing to do one. Obviously, if we find something, the wells that were done adjacently were sampled for basic parameters. This is more of a full suite of parameters that are going to be tested. Obviously, if there's an issue, we're going to be looking at more than one well.
Thank you.
And that's a test well that you're drilling, right? Something specific for sampling, and not something that's actually going to be one of these units wells. Is that
Yes,
correct?
it will be the final production well for the site. Which for the most part, if I was doing a big public water supply, would be a test well, but these are fairly narrow diameter wells that would go in.
Okay.
So yeah, it would be the final production well. So it would be installed by a Massachusetts driller. It would be installed in accordance with the requirements to meet the requirements of a private water supply.
Okay. And this would become one of the units wells if it passes and the unit's constructed.
That's correct.
Okay.
And you mentioned something that if you see something unusual or different, you would drill again. And I think one of the criteria for that would be, all the information we reviewed, as well as you from USGS and the nearby wells, indicates the aquifer is pretty homogeneous, not homogeneous, but consistent in its grain size, yield, and everything.
Yeah.
So if you see something like all of a sudden a whole lot of clay or silt, that'd be notable, and you would want to investigate that.
Absolutely. Absolutely. I mean, the goal is to provide, potable water for each one of these lots. So,
I'm sorry, gentlemen. I don't do this. I don't do the Zoom thing every day, so bear with me. But we do have one or two comments in the chat that I'd be happy to. I'd like to bring to your attention. One of them indicates that that there's not going to be a contamination, a sampling of surface water, according to the reports. Could you tell us why you're not going to do that?
Because the well that we're going to be putting in is located down gradient from Ricketts Pond. If there's any contamination in Ricketts Pond, it would show up in the well.
See, and the other comment is the Board of Health requires a well permit for all test wells. Anyone can chime in, but in this situation where the ZBA is the permitting authority, do we grant a permit for a test well, or do they have to go to the Board of Health, or how's that supposed to work? Or
That's
does it
beyond
apply?
me.
I think this board would be the one to permit granting authority for the comprehensive permit here.
All right. Well, it would seem to me that our conversation is essentially encompassing permission to test to drill a well for testing purposes. So I think that would essentially come under the rubric of our comprehensive permit. And so I think that's how we have to treat it.
Hmm.
One other question. Do you have an idea of how much water will be used in your calculations in this large development?
It would be based on, I can tell you that it's based on Title V flows, which are in I don't have it sitting in front of me. You'd have to ask Brad, I guess. It's around 13,000 gallons a day. That's the Title V
Yeah.
flow. That's Title V flow. The actual use will probably be about half that or less.
So
Title
I have your letter in front of
V.
me. It's
Oh, that's right.
13,860 gallons per day is what you had calculated in your letter.
Right. So
13,000.
that's the Title
That's
V
correct.
flow. Title V is usually is based on twice what the so that's two people for in each one of these bedrooms. Obviously, that's not the case. Usually, when you look at Title V flows, the real flow is somewhere around half of what the is half of what the Title V flow is.
And in this particular case, where each building is essentially a duplex, how do you factor in the fact that there'll be two families drawing on the water flow? Is that sort of baked into the 13,000 figure we've just heard, or do you need to
Yes.
adjust?
You're assuming that there's going to be two people in each one of the bedrooms. It doesn't matter if it's a duplex or not.
Right. And so, could you remind me how many bedrooms you've calculated for each structure?
All right, I'm going to pass that one on to Brad.
Mhm.
Sure, it's on the plan set, but approximately, I would say, I think 10% of the units need to be 3-bedroom units according to comprehensive permit regulations. So the rest will be 2-bedroom units. And as we've discussed, we've also discussed this with Mass DEP, and you've had correspondence from them a few months ago on our proposal to have individual wells serving more than one unit. We've agreed to limit each lot that has more than one duplex building. We're willing to condition that they all be 2-bedroom units to reduce the number of bedrooms per well.
All
I
right.
come up with 126 bedrooms based on your letter, Mr. Dillon. 54 2-bedrooms and 6 3-bedroom units.
Okay. So anyway, a question for GEI. I believe the report from GEI indicates that they recommended testing for Ricketts Pond, and I believe the applicant is saying we will test if the well shows signs of contamination. Is GEI will it accept that that proposal?
Yeah, we looked at that and we accept that. It was a really conservative recommendation to test the surface water.
Mhm.
And the applicant's rationale that surface water is equilibrium with the groundwater, and if anything's in the surface water, it will likely be found in the test well, I think is valid enough for me as long as they're doing the test well and those chemical parameters as recommended. In the surface water, there's no apparent ongoing source of contamination to the surface water. There's no reason to suspect the surface water would be contaminated now or in the future. It was a conservative, if you wanted to cover all your bases for where a potential source could be coming from, that was the basis for that recommendation.
And when you did that consideration, I know that you looked at the historical uses of the site to the extent that that they were available. Did you also factor in the construction of the highway into your concerns?
The construction of the highway, if I'm not mistaken on my geography, let me
Like Route 44, because it's sort of
Yeah.
adjacent north to the site. and it was obviously it was built there in the past quarter century, I think.
Yeah, that's about 1,000 feet in the down gradient direction. And so I don't think that would have factored into our consideration.
Okay. All right.
Mr. Chairman, may, may I just be heard briefly on just one issue?
Sure.
With with all due respect to Attorney Sheehan, on behalf of the applicant, we would like to contest and or object to Attorney Sheehan's comments without her identifying any abutters that she represents on this matter. Otherwise, we contest that she has standing
Well,
to participate.
I believe Mr. Galvin did say something about that in an email, but this is a public hearing, and we may consider the input of any member of the public, who they represent or not, whether she's an attorney or not, this is relevant. So if there's any sort of useful information to be had from any source, the board, I think, is entitled to consider it.
Understood.
Like-
Thank you. Just noting my objection for the record. Thank you.
I would.
I'd like to point out that Ms. Sheehan is filed no less than 6 lawsuits against us on the property, so I feel there's definitely a bias there to, disrupt our project here for no reason other than to just obstruct the construction of the project.
Yes, Mr. Opashinsky. I believe at least some members of the board are aware of the history between you and Ms. Sheehan. But anyway, in terms of the public consideration of this matter, we of course cannot shut out anybody's views unless they are, being disruptive or something like that. And obviously, this hearing, that's not unlikely to happen because it's a virtual hearing, and I have effective control of it, and nobody has misbehaved. So anyway, so now, I'm not sure. I just want to make sure that everyone has an opportunity to be heard because it's an issue that affects everybody. It is the water table. This Plympton is a sole source aquifer, so I think that everyone who wishes to, express concern can do so, and how the board deals with that will obviously be guided by the relevant statutes that relate to 40B. So anyway, let's see one more question for GEI. Did its recommendation take into account the dust from SLT's mining operation on Ricketts Pond?
We did not take into account that factor. I don't think it would factor in heavily to the groundwater quality. But I don't know how much dust they quantitatively produce, if it's monitored, and what the contents of that dust might be, other than silt and clay particles. So if there's a concern that I'm not aware of for contamination in the dust, then we'd like to have that information.
All right. Now to that, most people weren't here at the last hearing because it was a short hearing. Unfortunately, I was without power and could not conduct a hearing that night. But I do believe that I think it was that one or the one before. But I was the one before, because the last hearing we actually did have a physical hearing, and we decided that the applicant withdrew. There was a cease and desist order in place against alleged mining activity at the site, and the applicant filed an appeal of the zoning enforcement officer's cease and desist order, and it was agreed by the board in the mining and by the applicant that those hearings would be withdrawn, and that any issues to be dealt with regarding that will be handled in the context of these proceedings. So that is where I think that's the closest analogous movement on that matter. All right, so now I think we've had and anyone whose comments are in the chat here, obviously they'll be noted down as well, and I hope they will. What this program does, who God knows. All right, so anyway, with that, I think we've had discussion on the presentations. Now, the next subject is that there was a recent submission by Mr. Scott Horsley regarding certain concerns that were expressed. Now he's consulted the Board of Health hired independently, and there was email sent today. My suggestion would be if Mr. Horsley would like to speak briefly to his findings, we would listen to him, and then after that we can open it up for further conversation.
Yes, Mr. Chairman. Can you hear me okay?
Yes, please. So.
If I
just note one.
submit a letter, and I would like to share my screen, Mr. Chairman, if I may do that.
Sure.
Hopefully, I think you need to enable or something.
Yes, I think so. All right, let's see if that works. Or let's hope and pray it works.
Yeah.
Right.
Let's see. Okay, can you see my letterhead there?
Yes, we can see it.
All right. So I will. What I'd like to do is quickly walk through my comment letter that I submitted with you. This is actually a copy of it. I'm just going to scroll through it and highlight some of the tables and graphics in it. But I will start by introducing myself because I don't believe I appeared before you recently. So I am a hydrologist with about 30 years experience. Most of my work has been nationally for the U.S. Environmental Protection Agency. I've served on a number of advisory boards for Mass DEP, US EPA, and other organizations. I also teach at the graduate level at both Harvard University and Tufts University courses on hydrology, groundwater management, stormwater management, low impact development, etc. I provided a copy of my CV with my comment letter. In terms of general comments, this site is characterized by shallow depths of groundwater. As you know, it is within a Zone 2 drinking water protection area. And because it does provide both on-site septic systems and private wells, it does qualify as a nitrogen sensitive area under Title V. And I do have some comments on that. There are 25 septic systems, 25 lots that I've seen on the plans. Many of the lots averaging as small as 15,000 square feet. So this is a pretty dense development where septic systems and wells are in close proximity to each other. So I have 4 specific comments. As I said, this is a nitrogen sensitive area under Title V. And there are some performance standards that apply to nitrogen sensitive areas, specifically subdivisions that have both private wells and septic systems. One of those performance standards is no more than 440 gallons per day of wastewater discharge per acre. Now, I will mention, and I have a footnote in my letter, Mass DEP defines an acre slightly different than the rest of us. They define it as 40,000 square feet rather than 43,560 square feet. So I've taken that into account in my calculations. This is my first figure, which shows the site plan, and I've highlighted what I call the development portion of the development, which is the nitrogen sensitive area. There are also 2 other parcels that are called out by the applicant. Parcel A and Parcel B. If you can see my cursor, Parcel A is down here and circles around the subdivision. And that is identified, that includes wetlands as well as stormwater disposal. And then Parcel B is over here, which is the entrance to the subdivision where the cul-de-sac is. These are the calculations directly actually off of the site plan provided by McKenzie. The total lot area is about 24 acres. Parcel A is 11.28, parcel B 0.95. Therefore, the developed parcel, or what I'll refer to as the nitrogen sensitive area, is about 12.13 acres. What I've done is taken the simple calculation here, as we've already heard this evening, the The design flow, the wastewater flow for the development is 13,860 gallons per day. The developed parcel area is 12.13 acres. Simple math generates a load of about 1,049 gallons per acre per year. Now, again, in my letter, I've quoted back up here, Title V, which includes the 440 gallons per day per acre. There is also a provision for 550 gallons per day if a nitrogen sensitive, a nitrogen reducing septic system is used. However, my calculations suggest that this is 1,049 gallons per acre per day. So regardless of whether you're using the 440 or the 550 gallon per day standards in Title V, this development exceeds it by approximately a factor of 2. I also looked at each lot in the development. There are 25 of them, and I'll just scroll up and down here. The design flow for each lot is shown in this column. The area of the lot is shown here. And again, the nitrogen load calculation in gallons per day per acre is shown in the far right highlighted. And you can see they range from, I think, a low of 624 gallons per day up to about 2,226 gallons per day. All of these far in excess of the 440 or the 550 Title V requirements. Now, I understand that Peter Dillon is here from Geosciences, or Geoscience, I believe, is the name of his firm. And he has recommended that credit land should be considered in his letter to dilute these concentrations of nitrogen. However, parcel A, and I'll just go back up to my graphic here again. Sorry for the scrolling. Parcel A is down here. As I'll get to in a few minutes, the groundwater flow direction is northwest, this direction. So this area in parcel A is not going to provide any dilution of between any septic systems and private wells on these individual lots. So from a scientific standpoint, I don't believe that the suggestion of using parcel A as a method to dilute the wastewater, it makes sense to me. Furthermore, DEP, as I say here, specifically says that credit land is restricted to, and this is a quote from the DEP guidance document that I reference here, must be restricted to prohibit man-made sources of nitrogen. Well, parcel A has stormwater disposal on it. Stormwater has significant nitrogen load, and therefore parcel A can't be considered credit land for 2 reasons. It's upgradient. It's not going to provide any dilution between the septics and the wells. And secondly, as DEP says here, because it is a piece of land that has man-made sources of nitrogen on it, it can't be used as credit land. So that's my first comment. I have 4 comments, Mr. Chairman. The second one is that the nitrogen loading on the parcel result in concentrations that exceed the state and federal drinking water standards of 10 milligrams per liter. Now, I've done some calculations here. I've used the 27 inches per year, which I believe we all agree on. Peter Dillon, as well as GEI, I think we're all in agreement. That's the number that comes from the USGS Plymouth Carver Aquifer Study. So I've utilized that calculation. And what I've done is looked at the dilution of the development parcel with the Title V flows, and I've calculated an average concentration through that development area of 16.7 milligrams per liter. Again, the drinking water standard is 10 milligrams per liter, and as I'll get to in a few minutes, the recommended planning guideline, which refers to permitting, is actually 5 milligrams per liter. So this is 3 times the recommended planning guideline and over the drinking water standard of 10 milligrams per liter. My third comment goes more specifically to the individual lots. Again, this development proposal has opted not to provide a common drinking water supply in the open space, as I think was recommended and certainly makes sense to me. Instead, they've moved ahead with private wells and septics on each one of these lots. So I've quoted again Title V here. Um, when DEP considers 440 gallons per equivalency, and I'm just going to paraphrase here, go to the second sentence, when citing Title V systems and private wells in the same area, the location, depth, and construction of private wells and the hydraulic interactions between the septic system discharge and the private wells should be taken into account. That's a direct quote from the Mass DEP nitrogen loading guidelines. So that's exactly what I've done. I've looked at the hydraulic connections between the septic systems and the private wells, and I'm going to specifically refer to lots 2 through 12, which is in the northern part of the development, and I have a couple of graphics here. Mass DEP and their guidance document for doing nitrogen loading provides this graphic, and I'll just quickly explain what's going on here. First of all, as you can see, the groundwater flow is left to right in this diagram. The facility, which is the septic system in this case, is shown here. The recommended nitrogen loading is 35 milligrams per liter from the septic system, which is what I've used. And I'll mention as a side that I believe that is actually a low estimate. I have lots of data that I've published recently in peer-reviewed journals that suggest nitrogen concentration is actually probably more than double that. But nonetheless, that's the number DEP recommends using for these assessments. So I use that in my calculation at 35 milligrams per liter. I also include their recommended calculations for fertilizers. Now you can see they recommended an 18-inch recharge rate as a generic statewide number. I've opted to use the 27 inches per year, which I mentioned earlier, which actually dilutes the concentrations. And what this method does, it allows you to calculate the concentration of nitrogen that originates from the septic system to a down gradient location. In this case, they're talking about down gradient property locations. So here is a close-up of the subdivision plan for lots numbers 6, 7, and 8. You can see that the two septic systems on lots 7 and 8 are shown here. And the wells are shown here as little W's. The yellow area is what I have delineated as areas of impact in accordance with this Mass DEP guidance document. Now, the direction of flow here is actually off to the northwest here. And as I say in my my footnote, and I'll just scroll down to it here, I've actually used the direction of flow provided by GEI. They did a mod flow analysis that showed a northwesterly flow direction. So I've utilized that direction directly from the GEI mod flow. I've also used a direction of flow in accordance with the Zone 2 delineation, which is also consistent with that in a slightly more north-northwest direction. So I've identified these areas of impact. What this means is the wastewater is discharged from the leaching system here, and then it flows in this direction towards the northwest, towards these two wells. And what I've done is I've diluted the nitrogen from the wastewater using the 35 milligrams per liter with the recharge rate to calculate what the concentrations would be when they get to the wells. And here is my calculation for that area of impact. I'm calculating that the concentration at the wells would be around 22 milligrams per liter. This is more than double the state and federal drinking water standard. It's more than 4 times the Mass DEP recommended permitting or planning guideline of 5 milligrams per liter, which I'll get to in just a minute. And then I'm showing in my comment letter that I showed you a close-up for those individual lots, but in fact, this interaction, this hydraulic connection between septics and wells actually applies throughout all of these lots on the northwestern side of the proposed development because the lots are very similar sized. The placement of the septic systems and wells are very similar. My blue arrow here shows the direction of groundwater flow as a basis of the Zone 2 delineation, which is shown by these two red lines, a northwesterly flow direction, which is very consistent with what GEI modeled in their ModFlow model. So we do see a pretty confirmed direction of flow from the septic systems to the wells. And my last comment is number 4. I think you know this, but the town of Plympton has promulgated a health regulation because Plympton, unlike most communities in Massachusetts, is almost entirely dependent on private wells as a drinking water supply. So you need to take extra care to ensure that these drinking water supplies are going to be, clean going forward because you don't have a backup public water supply well. And the town has a health regulation requiring a 150-foot setback. This applicant has asked for a waiver from that. And according to my my calculations, that waiver, I'm getting a feedback, Mr. Chairman. I'll pause for a moment. Can you hear me okay?
Yeah, I'm still hearing the feedback a bit, but anyway, I can hear you, so.
I wasn't hearing that before. Should I continue? Can you hear me okay?
Yeah, I think BOH was having some issues, so they muted themselves. So why don't you go on ahead?
Okay, thank you. I'm almost done, Mr. Chairman. Oh, that's better. Somebody turned off. Thank you. So the applicant is asking for a waiver from the health regulation, which was put in place, and I quote the purpose of the regulation: to protect the public and environmental health, provide adequate water supply, wastewater treatment to ensure the residents a safe, clean, and healthy environment to live in. That's the purpose of the regulation. Again, the applicant has cited a waiver request to enable this development, and my recommendation would be not to grant that waiver in the view of protection of public health. My last comment, Mr. Chairman, is relative to a question you asked at the beginning, and that was relative, I think, to the testing requirements, testing of these wells. I believe the way this works is the wells would be tested before the development is built. Now, my belief is the development is the concern here. So testing the wells before the development is built, in my view, doesn't really provide much help in terms of whether or not these wells are going to be viable going forward. If one wants to grant this waiver and go ahead and risk the contamination of these wells, I would suggest doing the testing after the fact. And in that case, Mr. Chairman, we have a pretty dire situation here, in my view. We're going to have contaminated wells tested after the fact, because that's where the contamination will come from, the septic systems. And at that point, they're going to have to provide an alternative water supply source. So my recommendation would be to uphold the town's well thought out health regulation, which is developed under Mass General Law, Chapter 111, Section 31. I've testified in court on eight instances in Superior Court defending health regulations. They're upheld regularly. All of those 8 court decisions I've been involved in were successful. The only standard for these types of regulations, whether they are reasonable or not. This one is entirely reasonable. It's based upon public health. So this regulation, in my view, should stand, and the applicant should plan a development in accordance with protection of these drinking water supplies. Thank you, Mr. Chairman. I'd be happy to answer any questions you have.
All right. Thank you very much, Mr. Horsley.
You're welcome.
Sorry, did someone want to?
I have something, Mr. Chair. That's Attorney David Hennig on behalf of the applicant. Mr. Chair, we would submit to the board that Mr. Horsley's opinion and his testimony, he should not be considered neutral and unbiased in this case. We believe that he has been paid in the past on various projects by Attorney Sheehan, and I believe the board is aware of the prior history between the applicant and Attorney Sheehan in this matter. Further, we would submit that we believe the submission of this letter at this time is unfair to the applicant. Our consultant, Mr. Dillon, is traveling and hasn't been able to fully rebut Mr. Horsley's opinion at this time. But I would also note that the board's expert, Mr. Driscoll, agrees with our expert, Mr. Horsley. I'm sorry, agrees with our expert, and Mr. Horsley is just attempting to conflate the matters here. In the end, our applicant's proposing innovative technology, recirculating sand filter or equivalent with enhanced nitrogen removal to meet the state's nitrogen regulations, and the waiver request is included. And, we believe that with this technology, the waiver would be able to comply with the nitrogen standards. So for those reasons, we disagree with Mr. Horsley's testimony.
All right. Yes, and I believe Attorney Galvin said something along those lines. And I appreciate the fact that Mr. Horsley's letter was only received by most parties, if not all parties, today. And I think it would be fair. I think it would only be fair for the applicant to, if it requests time, to come and to provide a comprehensive rebuttal if it wishes. And I'd be prepared to entertain that at the next. Schedule the next meeting to for that to happen if that makes sense to everybody. But anyway, but I believe Mr. Horsley is being consulted not by Attorney Sheehan but by the Board of Health, who has retained him. So anyway, so as a as constituent member of the town, a fellow board of committees, who would ordinarily, if this was on 40B, be the permit granting authority, and has expertise that I would suggest that our members lack due to lack of experience. That has to be given into consideration, but ultimately it's our decision how we proceed. So with that, I appreciate everyone's comments to date, and I appreciate Mr. Horsley's presentation, but as I think it does raise questions that need to be addressed, and I think that that there should be time for to address them. I'd like to hear more about this nitrogen removal facility, system, for example, because there's not only the town, Mr. Horsley has pointed out not only that there's the town of Plympton's regulations, which indeed is, for those of us who live here and where it's not lost on us, but also that there are Title V regulations as well, which that has, those standards, I don't believe the board has authority to grant a comprehensive permit if they can't meet those standards. But we're not experts on that, so we like to hear
Chair?
on that point.
Mr. Chairman, can I offer a few comments?
Yes.
Brad McKenzie Engineering Group. We disagree with Mr. Horsley's assertion that Parcel A cannot be used as nitrogen credit land towards the nitrogen loading calculations, and our team will comment further on that. As you mentioned, we just got the letter. We get the letter about 2:00 today. Other than that, we are, as Attorney Hennig mentioned, we are offering enhanced nitrogen removal technologies that will provide 550 and 660 gallons per day per 40,000 square feet in accordance with Title V requirements. So that's item 1 in Mr. Horsley's letter. And again, we just received it. Items 2 through 4 don't really cite any non-compliance issues with Title V. So we believe the project fully complies with Title V. And I remind everyone that the applicant has paid in excess of $12,000 to the board's consultant, the zoning board's consultant, GEI, to prepare an evaluation of our experts, hydrogeo evaluation, and they've concluded that they agree with our assessment, our experts' assessment, and that the project meets Title V, and that essentially they've also recommended that the Board of Health or the zoning board grant waivers to local Board of Health regulations pertaining to septic systems and wells. So again, we've just received the report. We need an opportunity to respond, but we fully believe that the project complies with Title V. I might also add that your own civil engineering consultant, JDE, has confirmed in his last correspondence dated February 19th that we meet all of his concerns, and that the project generally is designed to meet state regulations with local waivers recommended, and that the state stormwater management regulation, the stormwater management design fully complies with Mass DEP standards.
All right, thank you, Mr. McKenzie. Now, at this particular moment, I'd like to talk to town council. I'd like to address something to town council. Carolyn, can you unmute yourself? So anyway, so we have a proposal. We have three separate group experts, or actually 3 or 4 actually separate groups of experts that have weighed in on the hydrogeology, and I think that there are some outstanding concerns that need to be addressed, with perhaps some specific fact finding by the board as to the applicability of the regulations of the nitrogen, handling capabilities of the land and that sort of thing. Would it make sense to schedule the next meeting to address those particular concerns, where everybody can come back and have an opportunity to present their findings to us, and then we can make some determinations on that going forward? I'm sorry,
Well, it's still muted.
I think you're still muted, or it's just the audio's not coming through. It says she's not muted. But I can, but if she, but I, maybe it's a bad connection. Can anyone hear?
I can't hear her.
Okay. Yes, as we can see, there are limits to our technology. All right, so
Mr. Chair, could she call in maybe on a phone?
I suppose, but I'm not sure how I route that through.
Well, she would.
Right.
There is usually the dial-in number for Zoom, is there not?
There is, yes. I guess there's definitely something wrong with the connection on her, probably on her end. So, let's see what we can do here. Okay, maybe she's logged off and logged back in.
Mhm.
You did provide a quick comment in the chat.
What would you say? Okay, all right. All right, so she said, I think everybody can everyone see the chat? Can other people see the chat?
Each person can
Okay,
toggle
all
it
right.
on or off.
I'm sorry, everybody. I'm treating it like this is just everybody's instant direct messaging, just me. But anyway, now that everyone can hear the chat, anyway, so and because it's being recorded, this may be a little more redundant than what people need, but she said, I'll try to log back in, but yes, it makes sense to continue the hearing to respond to the issues raised. And okay, so anyway, so I think that's probably the best thing that we should. I think that's probably the best thing that we should do. And I apologize to everyone who's going to have to come back, but I think there's issues that do need to be addressed, and I think the board would benefit from more factual, and the record would benefit from more factual development regarding the issues, the ones Mr. Horsley addressed. And anyway, so I would, while Calvin is hold on, okay, so let's see if I'm going to re-admit her and see if that things are improving.
Can you hear me now, Mr. Chair?
Yes, I can hear you now.
All right, try a different device. So I did type a message in the chat, but I don't know if you saw it just before.
Yes, we saw it.
Okay, so I do think it would make sense, the approach that you proposed.
All right, so I think at this point in time, the best thing would be for everyone to get out their scheduling, their calendars, and let's try and pick some dates. Wait a second, why don't I use my phone? I got another screen here. Okay, let's see. First of all, how long will we need to formulate responses? My suggestion is the week of the 13th.
Mr. Chair, I think we'll need to at least the end of April on the applicant side.
All right, if that's the case.
Well, Mr. Chairman, can I interject?
Yeah.
I defer to Mr. Dillon on how much time he might need to respond to Mr. Horsley's letter. I think Attorney Murray is I think the extension now is currently to the end of March.
The extension's to April 28th.
Right.
Oh, it is April 28th currently?
Yes.
Yeah.
But
Okay.
but if we're pushing out that far, we need a further extension.
I think we're agreeable to that. But I think Peter Dillon, how much time would you need to respond to Mr. Horsley's letter?
I think a couple of weeks. I don't know.
Weeks.
I need to read it and yeah. I mean,
Right.
I obviously disagree, but I need some time to read and comprehend.
All right. So and I think it's fair for both Mr. Dillon to have time to read, and if Mr. Horsley has anything to say in response to that, he should have
Exactly.
some time to consider your considerations. And so by the time, our next meeting, everyone who wishes to respond to what has been said here tonight, or to what's been said to the response, will have an opportunity to do so. So that might suggest, the week of, I can do the week. The week of May 4th.
For an extension or?
Well, we'd have to schedule a hearing with the understanding that there would be an accompanying extension to some time after that.
I think May 4th is like 5 weeks, 6 weeks away. I don't think we need that much time.
Okay, you might be right. I forget, we're not quite out of March yet. So let's see. All right. So So let's look at the week of May 20th. I'm sorry, not April 20th. That week seems to be enough time for everyone to do what they need to do. But if anyone suggests otherwise, speak now.
I don't have a problem with that, but I may not. It might need to be a Zoom meeting again. I'm spending a lot of time in New Mexico these days, and I may have to be there at that time period. So it's where I am now. So obviously I can Zoom in.
All right, that's not a problem. I think originally we had this meeting by Zoom because GEI's consultants are based in Connecticut, so we had it by Zoom so that they wouldn't have to travel. So we're perfectly happy to extend to everyone. So our next hearing on the subject will definitely be via Zoom only.
So, Mr. Chair, can I ask,
Yeah.
are you going to request that GEI offer an opinion on the Horsley letter? your own boards, your own consultant offer an opinion.
Greg, can you hear me?
Yes, sir.
All right. Anyway, that Mr. McKenzie raises a point. Would GEI be willing to commission GDE willing to commission ask GEI to speak up regarding the letter?
At the request of the board,
Yeah.
we would.
All right, and we make the request of Mr. Driscoll because technically speaking, GEI is a subcontractor of Mr. Driscoll. So it's Mr. Driscoll's
Available on April 28th, if that is
authority
the consider.
authority to order that. So, all right. So yes. So Mr. McKenzie, yes, we will ask our own consultant to advise us regarding the issues raised in the Horsey letter.
That they provide a cost estimate so we have an understanding as to what their review might cost the applicant.
How's that sound, Tom?
Yeah, I was about to chime in. We're happy to do that, and happy for the request. I think we'd like to take a look at those assumptions, put some additional data into our groundwater model, and support the response and the findings from Mr. Horsley's report.
Okay. Peter Obuchinsky, are you in agreement with paying for additional services for GEI to?
I'm struggling with the extension right now. I feel it's extremely unfair in this process to be ambushed by Mr. Horsley's letter this late in the process. I don't believe this is how the process is supposed to work, and I'm going to have Bob Galvin look into it and before I make any determination about providing any further extensions.
All right. Well, in that case, if the applicant is unwilling to provide, a further extension at this time, nonetheless, I would suggest that we do select another hearing date and take it as it comes. Ultimately, I think it would probably be in the best interest for everyone to agree to a further extension. But again, that's up to the applicant.
Yep, and I also need Paul Cusson to weigh on it. He's more familiar with the 40B process than obviously we are, and I just I'm not comfortable with how this hearing was conducted.
Very well. All right. That being said and noted, I would suggest Wednesday, April 22nd for our next hearing.
And what is the extension date currently?
All right. So the extension date currently is April 28th. But it doesn't seem to me like we can get everything done that needs to be done too much earlier than the week of the 20th. If you want to do April 20th, that works. But we are coming up pretty close on this next extension deadline.
So Peter Obuchinsky, are you going to authorize Peter Dillon to respond to Mr. Horsley's letter, or how do you want to proceed?
I'd like to confer with Bob Galvin and Paul Cusson on this, actually.
Okay.
All right. So I still think we should we're still going to schedule our next meeting. What happens there, I have to put in an agenda what we anticipate addressing that evening. So my suggestion is that we should have another meeting on April 20th, if that works for everybody's schedules. We have to tentatively schedule it because I know Attorney Galvin isn't here tonight. But propose one and put something so we have something for the next meeting. I believe, and I hope not to be speaking, too much, but I think that hydrogeology is probably the only major issue left in regarding this project before we come to the point of needing to make decisions and deliberate and issue a decision on this permit. So I think that the next hearing should be focused on hydrogeology and see what we can do. See what we can do from there.
Would it make sense to make another meeting sooner for like more of a check-in meeting to figure out what the if the applicant is going to extend the time and allow for GEI to respond? That way we can give him time, I guess, to confer with his experts and meet back and
Well,
have
I
a
think,
brief meeting.
I think what we could do regarding that, if there is going to be an issue, as long as we have 48 hours notice, we can convene we can convene a hearing to address scheduling scheduling and moving forward issues. Although technically we don't need a public hearing to address to address scheduling alone, but when it comes to issues like that, it should best be held. I think, I take someone's point that it should just be held openly if there's going to be an issue. Perhaps the parties can discuss and try to resolve matters. So anyway, but I think,
if I may to that point, if I may just interject on that point too, Mr. Chair, people are going to leave this hearing tonight. There are a number that, are listening. People are going to leave this hearing tonight waiting upon the motion that you make as to what that continuation date is. And if it's April 20th, we can't then come back, say on April 13th, for example, to discuss some of these housekeeping matters. So we need to make sure the public is fully aware and that we continue it to the next day that we think we're going to discuss anything related to this matter.
Well, I don't wish to schedule meetings, where we're not, at this point we're very late in the process where we're just discussing, a meeting where we're going to have a next meeting. So I would suggest that that on the 20th that everybody come prepared to deal with the remaining hydrogeology issues and just leave it at that.
And Mr. Chair, what happens if Mr. Opachinsky decides he's not going to authorize his consultant to respond to Mr. Horsley's letter and likewise isn't willing to pay additional money for the GEI peer review to do the same?
Then I think at that point, we would have to take the evidence as it is.
Okay.
However, there is an opportunity but he has absolutely an opportunity to respond. But until the public hearing is closed, if there's a reasonable opportunity to grant an applicant to respond to recent information, he should be granted that opportunity. But we, the board, should not be foreclosed from reviewing that information. All right, so.
Mr. Chair, should we continue this meeting for maybe 2 weeks out, just to afford Mr. Opachinsky an opportunity to talk to his counsel?
All right.
So we can determine how to move forward, and then from at that meeting we can talk about further extensions if necessary.
All right. Yeah, we can. I don't have an issue with it. I don't have an issue with that. So let's say that 2 weeks from now is April 7th. Does anyone have an issue with meeting for April 7th to discuss, I would expect to be a relatively short meeting to discuss.
Right, correct.
Going forward.
There won't be any new information presented.
All right. So,
Mr. Chairman, I don't think I am unavailable on the 7th, but I don't think it sounds like there'll be no substantive discussion other than scheduling. Is that correct?
That's my understanding. Yes, I think that's what's being proposed, and I would put that in the motion to continue. So we would not need your presence on the 7th.
Thank you, Mr. Chairman.
But of course, the meeting will be recorded. So if there's anything that you wish to apprise yourself that happened at that meeting, you're perfectly free to do so.
Thank you, Mr. Chairman.
Okay. All right. So I think what Mr. McKenzie says makes sense. And so anyway, so the proposal on the table, which is that we adjourn this hearing tonight and convene again in 2 weeks' time to discuss what discuss where we're going forward. I mean, after all, there is, as Mr. McKenzie says, Mr. Opachinski is paying for our consultant, and is and obviously, the bills. I hope they've already seen the bills, and they're not small. So I think that some time should be given to consider how best to go forward. So if no one has an issue with April, I'm sorry, what date are we looking for?
April 7th.
April 7th. All right. Does anyone have an issue with April 7th, other than Mr. Horsley, who's just spoke?
I do not.
All right. Let's see. Dave, are you okay with that date?
Yes, same time, 6:30.
Yeah. Suzanne, are you okay with that date?
Yes, I'm good.
Oh, no, I was asking Suzanne.
Oh, I thought you said Dave.
Oh. Okay, Suzanne is good. All right. Let's see. Okay. All right. Okay. All right. So. All right. Okay. All right. So everybody's good with that date. So I'm going to move that we continue this hearing until April 7th, 2026 at 6:30. It does not have, and as I understand, it doesn't have. Well, I think we best to do it by Zoom again, just so that if we schedule another meeting where we have a more, involved conversation about hydrogeology topics, that everyone can come in and and say, "Am I available that date?" Does that make sense to everybody? All right. No one's saying otherwise. So that makes
If
sense.
GEI is asked to look further at the report that was provided today, then it seems appropriate that if we're asked to do so in a couple of days before April 7th, we could have some thoughts by then, but potentially not a written response.
No,
I don't think that's the intent. We won't be in a position to authorize GEI to do any more work by that meeting. So I think a Zoom meeting would be appropriate because, as you said, it's just going to be a short meeting to afford the applicant an opportunity between now and then to talk to counsel, his 40B consultant, regarding, if he wants to pay for additional reviews or not, and how to move forward. So I think it's going to be a short meeting, so I think a Zoom meeting would be appropriate.
I agree with you, Mr. McKenzie. So that's what. So all right. So everybody understands, and who's on this side of the Zoom, that the next meeting will be a Zoom meeting at 6:30 on April 7th, where we will be discussing essentially scheduling the next meeting, authorization for further hydrogeology consultant services, and proposed deadlines for responses and comments. So that's what we're going to be talking about at the next meeting on April 7th. All right. So anyway, I've made a motion that we continue this meeting till April 7th. Do I have a second?
Okay.
Okay. All right. All in favor? Aye.
Aye.
And okay, Suzanne says aye, so we're all in favor. All right, with that, unless there's anything further that we need to address tonight at this hearing, I would entertain a motion to adjourn.
Well, just one thing, we were discussing waivers at the last meeting. Was that something you guys want to discuss tonight as well? There we go.
Okay. All right. So all right. So yes, the point is taken as to waivers. Now,
Mr. Chair, if I might on
Yes.
that, I think, we did discuss a number of the waivers, but we were also waiting for the hydrogeo report so that we could assess particularly the Board of Health waivers that are requested. If there's the possibility that there might be some further information coming, it seems to me it might make some sense to hold off on discussing those waivers until we have that further information.
Yes, I think what you say is sound.
Mhm.
All right, so we won't have, so that discussion won't happen at the next meeting. It'll happen at the meeting following it. So essentially, the idea is we get all the information that is going to be given to us, and then we can make our decision about about what waivers we grant and what we don't. But still, the evidence is still open. The evidence is still open until the public hearing is closed. So with that, we're not going to. So we won't be dealing with the further waiver review tonight. We will address that at the meeting following the next meeting. So with that out of the way, is there any other comment that wish to be made tonight before we move to adjourn? All right, then hearing nothing, then I would move that we adjourn this hearing and until April 7th. Do I have a second?
Okay.
All right, everyone in favor? Aye.
Aye.
Suzanne says aye. All right, so then we are adjourned. Thank you very much, everybody, for coming out tonight. I've listened with great interest to everything that everyone's had to say and the comments in the chat as well. And we will pick it up on the 7th.
Thanks, Ethan.
Thank you.
Thank you. Have a good night, everyone.
Thanks.
Thank you. Good
Have
night.
a good night, everyone.
That's true.